Good morning, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. It's 10 o'clock. We're here on Wednesday, August 18th, and docket number 2021-88E. Let's take roll. Present in the hearing room, we have Commissioners Caston, Thomas, Williams, C. Williams, Commissioner Powers, Vice Chair Belzer, and Chairman Williams. Joining us virtually, we have Commissioner Urban. General Counsel West Singer Hill, would you please read the docket? Oh, I'm sorry. Attorney Butler, if you would please read the docket.
Thank you and good morning, Mr. Chairman and other members of the commission. As the chairman has stated, the matter before you today is under docket number 2021-88E, which is Dominion Energy South Carolina Incorporated's 2021 avoided cost proceeding. This is filed pursuant to South Carolina Code annotated section 584120A. Dominion's application is for approval of the standard offer, avoided cost methodologies, form contract power purchase agreements, commitment to sell forms, and other appropriate terms and conditions that it proposes to use until at least such a time as an order is issued in its next avoided cost proceeding filed with this commission under the avoided cost statute. Mr. Chairman, other members of the commission, the docket is in order.
All right, thank you, Attorney Butler. Let's take appearances from the party applicant.
Good morning, Mr. Chairman and members of the commission. My name is Chad Burgess, and I'm in-house corporate counsel for Dominion Energy South Carolina. And with me today is Matthew Gissendaner. He's also in-house corporate counsel for the company. And I also have with me our outside counsel, the law firm of Willoughby and Hafer, specifically Mitchell Willoughby and Tracy Green. It's a pleasure to appear before you today, and we look forward to presenting the company's case. Thank you, Mr. Chairman.
Thank you, sir, and co-counsels. We're going to go to our interveners next. We're going to start with Johnson Development Associates.
Yes, sir, Mr. Chairman. Weston Adams and Court Walsh from Nelson Mullins. Mr. Chairman, with your permission, Court and I will tag team this hearing and each attend part of it. We will not both be here for the entire hearing.
Yes, that is no issue. Thank you for letting us know.
Thank you, sir.
South Carolina Department of Consumer Affairs.
Good morning, Mr. Chairman, members of the commission. Roger Hall, Department of Consumer Affairs. Also with me today is Connor Parker.
All right, thank you for joining us, sir. Carolina's Clean Energy Business Association.
Mr. Chairman and members of the commission, I'm Richard Witt from the Witt Law Firm, here representing the Carolina's Clean Energy Business Association. Also representing SECEBA is SECEBA's General Counsel, John Burns. Mr. Burns has been admitted for this hearing pro hoc vici.
Good morning, gentlemen, and thank you for joining us.
Thank you.
Thank you, Mr. Chairman.
Pine Gate Renewables, LLC.
Mr. Chairman, Richard Witt from the Witt Law Firm representing Pine Gate Renewables.
Hello, and with Mr. Witt is Bland Holman here. Good to see you, commissioners, and look forward to the proceeding.
Again, thank you for joining us this morning. South Carolina Coastal Conservation League, Southern Alliance for Clean Energy.
Good morning, Mr. Chairman. This is Tate Mixon on behalf of the South Carolina Coastal Conservation League and Southern Alliance for Clean Energy. And with me here today is Attorney Emma Clancy.
Good morning, ladies. Thank you for joining us. Office of Regulatory Staff.
Good morning, Mr. Chairman and members of the commission. This is Chris Huber here on behalf of the Office of Regulatory Staff, and I am joined this morning by Alex Knowles. Thank you.
Good morning, gentlemen. Thank you for joining us. Are there any matters we need to consider before the applicant calls its first witness? Hearing none, Attorney Burgess, if you...
Mr. Chairman?
Oh, I'm sorry.
Mr. Chairman, this is John Burns for the Carolinas Clean Energy Business Association, or CCBA. I just wanted to address briefly that there were some discussions yesterday, and without going into too much detail of what those were, I wanted to clarify with ORS and with Council for Dominion whether there was any movement on the proposal that went back and forth, particularly on the issue of whether ancillary services should be included in the PPA. I believe there was some agreement on that, but it was somewhat unclear, and I thought it might be worth, if I get shut down by ORS and Dominion right now, I'll say, fine, let's move on. But I wanted to clarify that for the record.
So, Mr. Chairman, this is Chad Burgess on behalf of Dominion Energy South Carolina. And I got to start off by saying I am stunned that Mr. Burns would bring up confidential discussions that were had among the parties and bring those to you at this point.
Mr. Burgess, I apologize if that's what you think I did, Mr. Burgess, but this was also in testimony between the two main witnesses, and I wanted to clarify whether that issue remains. I apologize if that was not correct.
Mr. Burns, with all due respect, I think you know exactly what you've done here. So, Mr. Chairman, I don't believe there's any preliminary matters to tend to. The company is prepared to present its case. Mr. Burns, certainly his client takes a different position, which we understand and respect. So, Mr. Chairman, I'm prepared to call Dominion Energy's first witness if the commission is inclined to allow us to do so.
That's fine, Mr. Burgess, and that's fine, Mr. Chairman. I'll retract that statement, and I believe Mr. Holman may have had one issue as well. I'll back off now. Thank you.
Yep. Mr. Chairman, I had a procedural point, and that is just if the chair and the commission were to deem it helpful, brief closing statements. I don't think that's in the current procedural order, but that at the close of this proceeding this week, if we could make a brief closing statement to help put some of this together, we'd appreciate that opportunity. I know that the company is interested in maybe doing that, Chad. I don't want to preempt you, but doing that at the close of the October proceeding. We would suggest that very briefly we could do it at both, but I just want to put that on the table.
Mr. Chairman, this is Chad Burgess on behalf of Dominion Energy South Carolina, and Mr. Holman's correct. The company would like to make a closing statement, but we think it would be appropriate for closing statements to be made at the conclusion of the hearing, which is scheduled to conclude in October. So we would request that the parties be allowed to present those closing statements at the conclusion of the hearing rather than in the middle of the hearing, which is going to be set to conclude, if not by the end of this week, by certainly early next week.
All right, I'll take the matter under advisement and let you know as soon as possible.
Thank you, Mr. Chairman.
Anything else? All right, Attorney Burgess, if you would, call your first witness, excuse me.
Good morning, Mr. Chairman. For the record, my name is Mitch Willoughby, and on behalf of Dominion Energy South Carolina, I will be calling our first witness, and the first witness that will be taking the stand in this proceeding is Mr. Danny Cassis. Mr. Cassis, good morning. And good morning. The court reporter will swear you, Mr. Cassis, and then I will begin to ask questions.
Attorney Willoughby?
Yes.
For some reason or another, sir, we're getting some feedback on your microphone. I'm being told by the live stream producers that there are two people in the room, in your room. So if one of those persons could turn their mic off while you're speaking.
I will, thank you, Mr. Chairman, and we will mute the other mic. So now, is it muted now? So that should accomplish hopefully that ends the feedback, Mr. Chairman.
It did, and we hear you loud and clear. Please continue.
Thank you very much. I will wait till the court reporter has sworn in Mr. Cassis.
Okay, Mr. Cassis, if you'll raise your right hand, please. Do you solemnly affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good morning, Mr. Cassis. If you would, please state your full name for the record.
Daniel F. Cassis,
And Mr. Cassis, by whom are you employed and in what capacity?
Dominion Energy, South Carolina is my employer, and I'm the general manager of partnerships, strategic partnerships, and renewables.
Now, in connection with this proceeding, Mr. Cassis, did you prepare or cause to be prepared and pre-filed direct testimony consisting of 46 pages?
I did.
Are there any corrections or changes to be made to that testimony this morning?
There are no changes.
If I asked you the questions that appear in that pre-filed direct testimony, Mr. Cassis, would your answers here today be the same?
They would be.
Mr. Chairman, I would move the introduction into the record of the pre-filed direct testimony consisting of 46 pages of Mr. Danny Cassis.
Mr. Cassis's pre-filed direct testimony will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Mr. Cassis, have you prepared a summary of your pre-filed direct testimony?
I have prepared a summary.
Please deliver the summary at this time.
Good morning, Chairman Williams and members of the commission. My name is Danny Cassis. I provided direct testimony in this docket on behalf of Dominion Energy, South Carolina on June 29th, 2021, and I respectfully request to provide the commission with the summary of the same. I'm the General Manager of Strategic Partnerships and Renewable Energy for DESC. In that role, I oversee customer-facing solar and all renewable energy initiatives for DESC. The purpose of my direct testimony is to provide a brief overview of PURPA and how those requirements relate to Act number 62 and this docket specifically. This docket arises from Act 62, which is in part how South Carolina implements PURPA. Specifically, this docket will examine the rates, forms, and contracts available to qualifying facilities, or QFs, under PURPA. Under PURPA, DESC is required to purchase power at rates that do not exceed the utility's avoided cost from these QF generators. This is sometimes referred to as the PURPA put. Not only does PURPA require DESC to purchase power from these QF generators at or below avoided cost, but PURPA also largely exempts QFs from federal and state utility regulation. Although DESC has historically received relatively few PURPA projects, there has been a tremendous increase in intermittent solar generation on the DES system in recent years. For example, in the summer of 2019, the nameplate capacity of utility scale solar generation on the DES system was approximately 498 megawatts. For the summer of 2020, the nameplate capacity of utility scale generation on the DES system was approximately 863 megawatts, approximately a 75 increase year over year, with utility scale generation capacity alone expected to exceed 1,000 megawatts in the near future. In total, there are 3,832 megawatts of additional planned solar and/or energy storage projects pending in DESC's state and federal interconnection queue, which is over 500 megawatts higher than DESC's average daily peak load. Although PURPA has been the primary driver of the increase in solar generation on the DES system in the recent years, going forward, the question is not whether there will be renewable sources and emerging technologies but whether the incorporation of renewable resources and emerging technologies will be done in a way that meets DESC customer needs in the most reliable and economic manner. QF solar developers may develop solar projects focusing on those items that ensure financial return without regard to system need or customer interest. Even though DESC does not identify a need in its IRP for long-term generating capacitor energy arising from new solar assets until around 2026, it is not excused from PURPA. DESC must continue to purchase under PURPA despite the significant amount of existing QF solar. In fact, DESC has to provide services to support the significant amount of QF solar generation during winter mornings and during evening peaks. Although energy storage can also help these needs with the current duration limits, energy storage as it exists today will not on its own allow DESC to achieve its ambitious carbon neutrality goals. DESC must have quick response resources to address the intermittency of solar and comply with mandatory NERC reliability requirements. Because DESC can only curtail these QFs without payment during a system emergency, DESC sometimes shuts down low-cost, flexible generation, which creates higher operational costs. DESC must also carry additional operating reserves to ensure that DESC is prepared for these large, unplanned drops in generation such that DESC's overall ability to reliably serve customers and balance the system is not adversely affected. As for the avoided cost structure, it was a central focus in the FERC's recent PURPA reform efforts. At a high level, these avoided costs were intended by Congress to act as the cap on the amount which utilities are required to buy power from QFs. PURPA makes clear that a utility may not pay higher costs than avoided costs. Yet, FERC's examination of avoided cost rates across the country reveals avoided cost rates have exceeded actual utility avoided costs. DESC's methodology to calculate these avoided costs is explained in greater detail by witness Bell and witness Neely. In addition, I provide the history of the VIC, the variable integration charge, and testimony in support of DESC's mitigation protocols that were first presented to the Commission in docket number 2019-184E. DESC has proven in past proceedings before the Commission that DESC's customers incur additional costs as a result of intermittent solar QFs on the DESC system. And the VIC ensures that these costs are borne by the cost causers and not DESC's customers. Finally, DESC is evaluating how to incorporate emerging technologies such as energy storage. Although these storage devices may qualify as a QF under PURPA, in order to do so, they must comply with PURPA's size and fuel limitations. However, if DESC employs DESC owned or called on storage, DESC will not be similarly limited by these limitations. DESC could deploy such devices in a way that first and foremost meets customers or system needs. Simply put, QF storage must be directly supplied by a QF generator, whereas DESC can use storage to take energy directly from the grid to better optimize all generation assets. I thank the Commission for its time, and this concludes the summary of my direct testimony.
Thank you very much, Mr. Cassis. Did you also prepare, or Colson prepare in this case, rebuttal testimony consisting of 17 pages?
I did.
And are there any corrections or changes to be made to your rebuttal testimony?
There are none.
I do not believe there were any exhibits attached to your rebuttal testimony. Is that correct, Mr. Cassis?
That's correct.
If I asked you the questions that appear in your pre-filed rebuttal testimony, Would your answers today from the stand be the same?
They would.
Thank you very much, Mr. Cassis. Mr. Chairman, we would move the introduction into the record of Mr. Cassis's rebuttal testimony as if given orally from the stand.
Mr. Cassis's rebuttal testimony will be entered into the record as if, given orally from the stand.
Thank you, Mr. Chairman. Mr. Cassis, have you prepared a summary of your rebuttal testimony?
I have.
Please deliver that at this time.
In my rebuttal testimony, I respond to the direct testimony of witness Horry, witness Levitas, witness Burgess, and witness Searcy. As for witness Horry, I agree with his statement that efficient integration of renewable energy creates additional costs for utilities. DESC implemented the VIC to ensure that those costs are borne by the cost causers and not DESC's customers. In preparation for this proceeding, DESC engaged Guidehouse to perform a comprehensive analysis of the DESC system, which yet again revealed the existence of incremental costs arising directly from the integration of solar QF generation. Although DESC proves through detailed analysis that the current interim VIC remains lower than the actual cost incurred by DESC to maintain these incremental operating reserves, DESC is willing to accept witness Horry's recommendation to keep the interim value at this level so long as the VIC remains subject to future true-up. As for witness Levitas, I note that his lack of explanation as to whether SECIBA is aligned on all the opinions advanced in his testimony or whether the testimony simply reflects his personal experience in his role with Pinegate. Additionally, witness Levitas again advances a commercially reasonable standard that has been recognized by the Commission in DESC's prior avoided costs docket as impractical to implement. This is a standard which is glaring for its failure to consider DESC's customers and appears to primarily consider the interest of QF developers. Witness Levitas also attempts to weave into his proposed standard that selective terms and conditions contained in existing documents that were litigated for the Commission should be presumed to meet the standard. However, witness Levitas misunderstands the point of the exercise. DESC has added insight since prior proceedings, in part due to the higher levels of intermittent resource on its system. The insight and the corresponding proposed changes to protect customers and promote reliability are a required part of DESC's review and consideration in this docket. To the extent witness Levitas places confidence in existing documents because they were litigated for the Commission, he can be assured that any changes resulting from this proceeding will have undergone an identical process. Although witness Folsom will address the majority of witness Levitas's concerns with DESC proposed changes in this docket to the form PPA, standard offer, and NOC form, my testimony addresses witness Levitas' issue with statement of ancillary services under the form PPA. Witness Levitas requests changes related to ancillary services and in particular reactive power. However, these issues must be addressed on a case-by-case basis and evaluated in the context of the capabilities of a specific QF generator. Therefore, it is not appropriate to incorporate this requested change into DESC's form documents. The form provides the necessary flexibility to deal with projects on a case-by-case basis, but witness Levitas' request would eliminate that flexibility. Finally, witness Levitas suggests that the interim VIC has created difficulties in the marketplace for QF development. However, the facts show the exact opposite. DESC has 17 QF solar projects with PPAs under which they agreed to pay the VIC at whatever amount is approved by the Commission. Of those 17 projects, 16 have reached commercial operation, and the 17th is expected to do so early next year. This actual data clearly refutes witness Levitas' words and must have the presumption of reasonableness given that the data explains what actually happened in the marketplace. As for witness Burgess, I rebut his claim that DESC did not receive stakeholder input when establishing its VIC by citing the numerous proceedings before the Commission in which the VIC has been examined not only by industry stakeholders, but also the Commission and its third-party expert. Finally, witness seriously claims that DSC has not met the standard of transparency required by Act 62. Again, the actual facts refute these claims. DESC responded to 14 sets of discovery in this docket, totaling over 90 questions, and even responded to 7 of the 14 sets prior to the required deadline. There were no motions to compel. Consistent with these facts, and in sharp contrast to witness Searcy, witness Horry expressly acknowledged DESC's transparency in this docket. I thank the commission for its time, and this concludes the summary of my rebuttal testimony.
Thank you very much, Mr. Cassis. Mr. Chairman, Mr. Cassis is available for questions from the parties or from the commission at this time.
All right, sir. Johnson Development Associates. Cross-examination.
Mr. Chairman, no questions from Johnson.
Carolina's Clean Energy Business Association.
Yes, Mr. Chairman, John Burns for CCBA. I do have a few questions for the witness.
Please proceed, sir.
Thank you, Mr. Chairman. Mr. Cassis, thank you for your testimony today. We haven't had the opportunity to speak, but I'm John Burns. I'm the general counsel for CCBA. And I just have a few questions primarily about your rebuttal testimony, if you don't mind. First of all, if you look, and I believe you have your testimony in front of you.
I do.
Okay. Mr. Chairman, would you like me to pull up testimony when referred to and share screen, or if I refer to it by page and line, are you able to follow along?
If you have the capability to pull it up easily, that will be the preference.
Yes, excellent. I'll do that. I'll ask your and the commission's indulgence at first as I stumble through this thing a little bit, but we'll get it. I got it last time, so I think I can probably get it this time. I'll refer your attention, sir, to page 4 of your rebuttal testimony, and I will enlarge that a bit. Is that legible, Mr. Chairman?
If you could enlarge it a bit more. Thank you.
That might have been too far. Okay. All right, I'll ask you to take a look at lines 3 through 7 of your testimony on page 4, Mr. Cassis. You testified that this commission held in a prior order that an interim VIC of $2.29 per megawatt hour was just and reasonable to customers, consistent with PURPA and FERC regulations and orders, non-discriminatory to QFs, and serves to reduce the risk placed on the using and consuming public. Do you see that?
I do.
Did I read that correctly?
You did.
All right. And that's from order number 2019-847. Is that right?
That's correct.
Are you aware, Mr. Cassis, that the commission revised that order through the issuance of order number 2020-244?
I am, and that's further down in the testimony.
Okay. You understand that a revised order reflects the commission's decision in that docket and not the original order, don't you?
I do.
Okay. And so the portion of your testimony here that says the commission established a $2.29 per megawatt hour VIC was superseded by the commission's later order, wasn't it?
I agree.
Okay. So you're not suggesting that any proceeding before this commission has adopted a VIC higher than 96 cents per megawatt hour with a right to true up, are you?
No, just the plain language in the direct that it was a 229 and 219-847, and then there's a follow-up from line 7 through 10 that has the subsequent order.
All right, so the amount was reduced, and the 229 megawatt hour was never established by the commission as a final order, was it?
No, it was the 96 as the interim, and then there was the true up provision that was included. That's correct.
And so the commission rejected Dominion's proposal in the last avoided cost proceeding and has never established a fixed VIC for Dominion, South Carolina, has it?
No, it's a 96 cent per megawatt hour interim VIC, and there's a true up provision.
Okay. Thank you. So when you say that a long and detailed record establishes a higher permanent VIC, that's just your opinion, is that right?
It's a result of analysis that was done by experts that have provided testimony and have provided information on discovery.
But the commission has not shared that opinion, has it, to date?
So far, the commission has determined that there's a 96-cent interim and that there's a true-up as a result once a permanent VIC is established.
Thank you. If you'll look at page 5, and I hope I don't make anyone dizzy by scanning through this. Pages 10, lines 10 through 12 of page 5 of your testimony that begins in preparation for the filings. You state that Dominion engaged Guidehouse, a nationally recognized independent consulting firm. Are you contending in this, or is Dominion contending in this proceeding that Guidehouse is not paid by Dominion and the study isn't shaped and informed by Dominion?
We provide the data to Guidehouse. So the same data that we provide as requested by any of the interveners, that same data is provided to Guidehouse, and we ask them to independently solve for what are the operating reserves that QF Solar is incurring on our customers and on the system.
But Guidehouse is not really an independent consulting firm as one would understand that term, since they're being paid by Dominion to testify in this case, correct?
Well, I would say that we've clearly provided them the information. And if you're asking if we paid them as a consultant, yeah, usually consultants don't work for free. Sure. So we had to pay them. But
I just want,
yeah.
I'm sorry, go ahead and finish your answer. I don't mean to interrupt.
Yeah, no, so yeah, the fact that they're can remain independent, I think that's we weren't imposing them to get an answer. We just asked them to solve. And actually, I think they're the only one in the docket who's actually done a study.
Thank you. Turning to page 6 of your testimony, looking at lines 9 through 12. You see the line, that's the sentence that starts the additional reserves. You state in your test.
Yep.
You do that. You see it. Good. In that section of your testimony, you testify that the additional reserves DESC maintains are for the purpose of accommodating solar and ensuring reliability. Correct?
That's correct.
You're familiar with the testimony of the other Dominion witnesses in this proceeding? Have you reviewed it?
I am.
Do you understand that the Guidehouse study is not based on Dominion's actual historical and current operations?
So the study's based on, it's a forward-looking study. So it not only does it look at the current fleet, but it actually looks at the assets and the renewable energy that's been integrated and how the system will operate going forward.
But it's not looking, it's based on the Guidehouse's testimony through its representative is that it's not, their opinion is not based upon the actual reserves maintained by Dominion, but on a forecast of what they should be. Is that right?
So again, they were, as you noted, they're an independent. We completely asked them to be independent and to evaluate the system and actually do it in a way that was looking forward so that we could clearly identify the costs that were associated with intermittent variable renewable generators.
Well, I'll ask you to take a look, and you should have it already. And if they're not, let me check with Mr. Willoughby. Mr. Willoughby, did you receive from staff the Carolinas Clean Energy Business Association's cross-examination exhibits? You're muted, Mr. Willoughby. I'm sorry.
No, I have not received them. When were they sent?
Well, I thought they were sent yesterday afternoon, but I will. Bear with me just one moment, Mr. Chairman. I can have them all forwarded to you, and I'd ask Mr. Witt if he would be able to send that email, forward the email that Carrie sent to the staff. If you would forward that directly to Mr. Willoughby, I would appreciate it.
Yes, and I just want to point out that all of those exhibits, cross exhibits, were sent electronically to Ms. Wilson yesterday afternoon, Mitch.
Okay, well, we didn't, Richard, we didn't get them.
Okay. Okay, we'll send them.
And in the meantime, Mr. Willoughby, I will make this representation right now that the first cross-examination exhibit that I'm going to bring up for Mr. Cassis is just a blow-up of a chart that was table number 1 to Mr. Witness Burgess's direct testimony. So it's something that everyone has seen. In the meantime, you should receive shortly all of the cross-examination exhibits. Thank you. And I'm going to share my screen. Mr. Cassis, if you will take a look at cross-examination exhibit number 17, what's been previously marked. This is a chart from Mr. Burgess's direct testimony. Did you have a chance to review Mr. Burgess's direct testimony?
I did look at his direct testimony.
Okay.
I don't remember every bit of detail.
No, that's fine, and I wouldn't expect you to. I just want to make sure you've had an opportunity to see this chart. This chart is table 1 in Mr. Burgess's direct, and we've also identified it as cross exhibits 17, just for ease of reference. If you look at this chart, can you explain to me why the historical operating reserves maintained by Dominion from July 2016 to June 2017 are virtually identical between the years when Dominion had almost no solar on its system as compared to the years in 2020 to 2021 when Dominion had significant additions of solar to its system here in column 3.
Mr. Cassis, before you answer that question, Mr. Burns, if you would, please enlarge that document for us, please.
Yes, sir. Is that better?
You.
Is it legible now, Mr. Chairman? I've got it at 200%.
Yes, please proceed.
Okay, thank you. And please don't hesitate to interrupt because I can't really see what I'm showing except in this very tiny little screen in the corner of my other screen. So thank you. Mr. Cassis, I'll repeat my question. Can you explain to me why the historical operating reserves maintained by Dominion are virtually identical in columns 2 and column 3 between years in column 1 when there was very little solar or no solar on the Dominion system, and the years in column 3 when there was significant amount of tranche 1 already deployed?
Yeah, I wouldn't be able to tell you really on 16 and 17.
Okay.
And why there would be no difference. Again, I point to the concept that most of the solar has, and at least that second tranche has come on. I know the system operators, and specifically Mr. Hanslick, has a wealth of experience on operating the system. So I think it would be most appropriate for him to answer the question.
Mm-hmm.
I distinguish the difference between what the independent analysis that was done by Guidehouse. That's a forward-looking analysis, so it incorporates multiple scenarios of operating the system. And I mean, these are shorter periods, so it's designed as a Guidehouse study is essentially designed to look forward to capture costs for additional operating reserve. I think there's a distinction between those two, but I think the witnesses can make that clear.
But you will agree with me, won't you, that the numbers in column 2 for historical reserves for each of those months are very similar, in many cases less than or greater than the numbers in column 3 for July 2020 through June 2021.
Yeah, I think it really depends on the system and what's happening on the system. So I wouldn't make any representations about what assets were running, what load was there, what load was not there. I think it's a very
Understood.
specific scenario, which is why we asked an independent entity like Guidehouse to do the analysis for us.
And just to clarify, you testified, as we just said, on page 6, lines 9 through 12, that the additional reserves DES maintains are for the purpose of accommodating solar and ensuring reliability. That was your testimony.
Yeah, the additional reserves DES maintains are to prepare for large unplanned drops in generation.
But you testifying here today cannot explain, and you defer to witness Hanslick and others to explain why the reserves maintained through June of 2021 are no greater than the reserves maintained in July 2016 to June 2017.
Yeah, as I did explain that I think there are probably differences, but the other witnesses can explain why, specifically someone like witness Hanslick, who operates the system every day and ensures its reliability and ensures there are no issues and falls within the NERC requirements. He would be the expert on that, why those reserves were held.
Understood, and thank you. We could turn to some of the contract issues that you discussed in your rebuttal testimony. And let me get to the right page before I turn it on. If you'll turn to page 7 of your rebuttal. You, beginning on that page, you begin to discuss the rebuttal to testimony provided by CCBA witness Steve Levitas. Is that right?
That's correct.
All right. First, in your testimony, you challenge whether Mr. Levitas, who is a witness introduced by CCBA, is in fact a CCBA witness at all. We'll deal with that later. So I want to move to your next challenge. You confront Mr. Levitas's testimony, and you contend, I think, that he is improperly asking this commission to apply a commercial reasonableness standard in evaluating Dominion's PPA's terms and conditions. Is that right?
Witness Levitas addresses or asks for the commercial reasonableness standard to be included. The previous commission, in a litigated docket, did determine that that was a standard it was almost impossible to actually enforce, or actually to clearly define.
All right. And you state that in docket number 2019-184E, and I'm referring to line 13 of page 8 of your testimony. I guess it's page 8 of 17, line 13. The commission declined to adopt such a standard, noting that, quote, attempting to define the term commercial reasonableness in this context would likely exacerbate disputes between QFs and DESC over the meaning of the language. And that's a quote that you pulled from the order itself, right?
It's from the order. Yes, sir.
All right. Let me ask you is it still your position that the commission should not hold the provisions of Dominion's proposed PPA and other documents to a standard of commercial reasonableness?
My position is that the commercial reasonableness is one of the things in the act, but not the only thing in the act. And I think that it's just hard to define what is commercially reasonable.
Understood. Let me turn your attention then to cross-examination exhibit 1, which is nothing more than a copy of section 58 of the statute. Particularly 58-41-20B. And I'll get down to it and highlight it for you. Here's 58-41-20. Do you see that?
I do.
Okay. Section 58-41-20 defines the what needs to be reviewed by the commission, correct?
Yep, that's correct.
All right. And in section B, on the next page of this exhibit, The statute says that in implementing this chapter, the commission shall treat small power producers on a fair and equal footing with electrical utility-owned resources by ensuring that, and jumping down to 2, power purchase agreements, including terms and conditions, are commercially reasonable and consistent with regulations and orders promulgated by the FERC implementing PURPA. Did I read that correctly?
You did read that correctly.
All right. On page 8 of your rebuttal testimony, you state that the commission declined to adopt such a standard in its prior order, right?
Yep, that's correct.
So based on that, you contend that the whole concept of commercial reasonableness has been rejected by this commission?
No, I don't think it's been rejected. I think that that B2 is part of the act, but it's in totality, it's with the other things that are also inclusive in that section of the law. So it is very, my point is that it's very hard to define what is commercial reasonableness. I think both parties could argue all day what's commercially reasonable. You're talking to the guy who's done 1,000 megawatts of solar. I think I've been numerous times I've been told by developers and representatives of developers that things that are in contracts are either non-financeable or they're not commercially reasonable. I think on all 17 contracts where there was a VIC clause, every one of those, I was told they were commercially unreasonable. Every one of those projects financed, and 16 of them are in service. But I was adamant. I can tell you where I was when most of those conversations took place too.
Thank you. Isn't it the case, Mr. Cassis, that in that final order, the commission rejected many of Dominion's proposed PPA terms and conditions precisely because it agreed with Mr. Levitas that they were commercially unreasonable?
I can't really speak for the commission on why they rejected terms. I think, in an avoided cost docket, I think we're really here in the end of the day to ensure that PURPA is enacted properly and that consumers are protected and ratepayers are protected, but it also gives rights to small power producers that want to develop projects. So I think that's the balance. So I wouldn't necessarily agree that I can't speak for the commission.
Thank you.
Yep.
I appreciate that answer. And would you agree with me that the commission's order speaks for itself and neither of us can speak for the commission?
Yeah, including their thoughts on commercial reasonableness. I agree.
In that case, what the commission rejected was Mr. Levitas's request in his testimony in that docket that the commission place a definition of commercial reasonableness in the standard offer in PPA itself. Correct?
That's correct.
All right. And the opinion held, or the order held, that in this regard, witness Levitas proposed to include a definition of commercial reasonableness in the standard offer in form PPA. But Mr. Levitas is not asking Dominion or the commission to put a definition of commercial reasonableness in Dominion's documents in this docket, is he?
I don't remember if he was, but I will take your word if that's what you say, that he's not.
Okay. He's asking the commission to determine if the terms proposed by the company are commercially reasonable or not. And he's arguing that some of them are not, right?
I believe that's his position.
Okay. Turning to the issue of the VIC, you take issue in your rebuttal testimony with Mr. Levitas's statement that the VIC subject to true-up has made it difficult to finance projects in South Carolina since the order was issued. Is that correct?
I do.
To your knowledge, Mr. Cassis, has Dominion executed any PPAs with small power producers or QFs with an interim VIC in the last 2 years?
That we haven't until well, let me say this: we haven't with the interim VIC, but I think there's a different reason. It's not evidence that because no one signed it. Most developers are pursuing different projects. They're pursuing hybrid projects, and they're creating assets which are what I would describe as potential mitigators of the operating reserve issue. So there are other things that are clear that are reasons why there hasn't been immediate development. COVID being one, a FERC case, Broadview, being two, which stymied a lot of developers in the short term. But even during that time, there were robust negotiations. They just weren't negotiations around PV only. They were hybridized assets that included storage.
I appreciate you bringing that up. Just as a side, is Dominion offering a fixed VIC in those hybrid contracts?
It depends specifically on what the product that's being offered. So if the analysis of the asset is performed and that information is then shared with the developer via price discovery, it depends on how they would operate it. So a certain type of hybridized asset where, for instance, the company operated or actually provided signals, there's a decent chance that that could eliminate operating reserve. You could understand how that asset could then be charged during periods where there was a need for reserve, and you could reduce the operating reserve. But if a developer wants to provide an asset that they control, it's less certain whether they could mitigate the VIC. It is a very, very dependent asset specific calculation.
But in some of those hybrid asset PPAs, there are fixed VICs.
Yes, so
okay.
We ended in so we had a settlement, Counselor, on an asset that committed to a PPA in 2018. And then they had trouble bringing the project to fruition. For various reasons, we entered into a settlement. And in that case, the settlement specifically described a fixed VIC.
Okay.
For that, and that VIC was $2.29, actually, and that was amended, and that contracts went before the commission, I believe in May of 2020. I think I have I don't have the exact date, but you can go back and look at those. So that would be a $2.29 fixed VIC that developer agreed to.
Thank you. And now coming back to my earlier question, to be clear, the company has not executed a PPA with a interim VIC or an indeterminate VIC in the last 2 years, has it?
Only because those projects haven't been presented at all. I mean, the projects that we're looking at now with developers and the business development folks, they're hybridized. So they're just not straight PVQF mandatory purchase obligation. If someone came to us with that type of project, then, I mean, obviously we would enter into negotiations.
And that's your understanding of why those haven't been done, but others may have differing understandings of why developers may not have entered into those types of PPAs in the last 2 years, right?
I would base my answer on my extensive experience in discussing with many of the members in the industry. They're not just SEBA, but some of them are, but they're members that may not be interested today. But that information that I provided relative to COVID, relative to Broadview, relative to interconnection queue as being issues, those are much more critical issues, I think, in moving projects forward. No one said, I can't get anything done because you've got this interim VIC. I haven't had a single developer say that to me. And my conversations are ongoing. Matter of fact, I have conversations. I have a weekly meeting, for instance, with Pinegate, with the business development team. I don't think they've ever told me that, ever, one time.
Thank you. You did, though, mention in your testimony 17 PPAs on page 14 of your rebuttal testimony, right?
Yeah, those are all PPAs that had the language, and actually I called out the language in the.
I'm sorry, Mr. Cassis, you were going to go ahead. I don't want to interrupt you.
Yeah, I just called out the language. I'm not going to read you the language, but it was language that was on my rebuttal. It was page 14 and it was line 5 through 18.
But to be clear, none of those were executed in the last 2 years, were they?
No, they all were executed with that language. And actually if I can go back and recall who the 17 were, almost every one of the developers initially told me that contract was non-financeable and it wasn't commercially reasonable. And all of them got financing, and actually all 17 are going to get built. 16 are already built. That's 632 megawatts got built with that language.
Understood. Turning to the issue of surety bonds, I think there's a dispute between you and Mr. Levitas and between Mr. Levitas and Mr. Folsom about the provisions of that are changed related to surety bonds. It's true, isn't it, that Dominion has previously proposed and this commission has approved the use as one form of performance assurance surety bonds for PURPA PPAs, right?
That's correct.
Forgive the awkward wording of that sentence. I got turned around in the middle of it. Dominion has approved surety bonds as a form of performance assurance for PURPA PPAs, correct?
That's correct.
Thank you. It's also the case, is it not, that Dominion previously proposed and this commission approved a form surety bond for that very purpose?
That's correct.
Am I right that that form was similar to the surety bond form previously used by Dominion and its predecessor, SC&G?
Yeah, very, very similar. Correct.
And a number of small power producers have successfully used Dominion's prior surety bond form to obtain surety bonds for PPA performance security, haven't they?
They have.
But now, based on your testimony and that of Mr. Folsom and the forms attached to it, Dominion seeks to replace that approved form surety bond with a new modified form, correct?
That's correct.
And the modified surety bond that Dominion proposes requires that the surety pay on demand within 10 days rather than the 15 of the prior bond form, right?
That's correct.
It also requires the surety to waive upfront any defenses, waivers, counterclaims, or objections to payment so that it is in essence a promise of payment on demand with no defense, correct?
That's correct.
Do you have any basis sitting here today to dispute Mr. Levitas's testimony that those new conditions will make it difficult for small power producers, if not impossible, for them to obtain a surety bond?
I can't say for sure because I haven't actually spoken to folks in the market. I think witness Levitas used the word maybe eviscerate, that it would destroy the opportunity. I don't believe that's the case. But I will admit that I haven't talked to other developers that we're currently talking to about projects. And some may be SECEPA members and some may not. But I don't think the changes are in the scope of creating a commercially reasonable contract. I do not think that it would limit the ability to achieve financing. I think those are, matter of fact, I think if I'm not mistaken, and witness Folsom is probably going to be the best person to answer, but I do believe most of the suggested changes, and I think they're relatively minor, they're utilized by the parent company. So it's a similar form to what's used, for instance, in Virginia. And which is obviously deemed to be commercially reasonable.
Are you personally aware of any instance in which a small power producer has successfully obtained a surety bond containing these new conditions?
No, I'm not personally.
The waiver of defenses.
I'm not personally. And actually, we would have tested the market likely if we get it approved. And obviously, we haven't had a lot of activity, as we previously described, for the reasons I already previously noted.
Are you familiar with the letter of credit or the concept of the letter?
The concept, yeah.
Are you aware that one of the primary differences between a letter of credit and a surety bond is the right of the surety to advance defenses against improper claims?
Yeah, I'm not a credit expert, but I respect the wisdom of the corporate Parrott and some of the things that they've said we should change or make differences or, you know, create something that's improved and creates protection.
And the reason behind this, you've stated in your testimony, the reason behind these changes is to meet the different, or to provide assurance to the company that the QF will perform its obligations under the PPA. Is that right? That's the purpose of the surety
That's
bond?
correct. Yep.
Are you aware, as you described yourself as the person responsible for negotiating and obtaining final approval for renewable energy purchase contracts for Dominion? That's how you describe yourself, right?
That's correct.
Okay. Are you aware, as that person, of any situation where Dominion, South Carolina, has been required to execute on a surety bond used for PPA performance assurance?
I don't know of a case where we've had to, but I'm certainly glad that we do have it in the event that something does happen. We certainly have issues with assets that are QFs, and that's in my direct testimony, but I haven't had to call on it. That's an accurate statement.
Okay. And so then you would also not be aware of any instance in which a surety for a PPA in Dominion, South Carolina's territory has been asked to make payment and improperly refused to do so.
I have not, no.
On the issue of insurance, I just have one question for you. Dominion seeks to raise the levels of required insurance substantially in its proposed documents. Are you aware of any claim made by Dominion against any insurance policy issued to cover any QF in the last 6 years?
No, I'm not.
Would anyone else at Dominion have that information if you don't?
I don't think that there is. I think you could ask that question of witness Folsom.
Okay. Is that your full answer?
That's correct.
Okay, thank you. Also, during your rebuttal on page 11, you confirmed that ancillary services are not included in the calculation of avoided costs. And I'll turn to that just so that we can look at it together, if you don't mind. Because one of the additional changes, well, one of the issues between the parties here is the inclusion of ancillary services as energy, correct?
That seems to be an issue.
Okay. Looking at page 11 of your testimony, you address Mr. Levitis's testimony in your rebuttal here. And you say ancillary services are not included in the calculation of avoided costs. Do you see that in the first line of line 19?
Yep.
On page 13, you state that the foreign PPA language giving those ancillary services to Dominion, quote, at no additional cost, does not, and let me get to that page for you, 12, 13. Pardon me. I'll rephrase my question once I find it. Pardon me. Here we go. On line 10, you're referring to the inclusion of ancillary services at no additional cost, and you state that this reference does not preclude Dominion, South Carolina from negotiating with a QF generator capable of providing such services if and when Dominion has a need, right?
That's correct. I mean, in order to be compensated, the services would have to be avoided.
Act 62 requires that the commission treat small power producers on a fair and equal footing with electrical utility-owned resources, doesn't it?
It does. It also requires that you don't pay more than avoided cost. So therefore, if there were services that weren't avoided, then there wouldn't be a need for compensation.
And
So,
yep. Sorry, were you not complete?
You're fine. Yep, you're good.
Okay.
Yep.
And one way that Act 62 does that is to ensure that avoided cost rates, quote, fully reflect the utility's avoided costs with a methodology that, quote, fairly accounts for costs avoided, including ancillary services provided by or consumed by small power producers including those utilizing energy storage equipment. That's in section 58-41-20B that we looked at earlier, correct?
Yep, I see it.
All right. At a minimum, wouldn't you agree that the commission should require Dominion to remove the language in the PPA purporting to give Dominion these ancillary services for free?
So the ancillary services aren't delivered for free. So to be clear, the foreign PPA, it calculates avoided energy and avoided capacity. And if an entity wanted to deliver services and they could demonstrate on a very project specific basis, then that would be included. It would be an easy and flexible way to address in a bilateral contract. So the foreign PPA and the standard offer, those documents, all they do is address avoided cost, energy limited PV. As we already noted, there are other types of projects that are advancing, but you have to have a standard or a base. So what I would tell you is that if you don't avoid anything, there can't be a method for compensation. In other words, if you can't provide operating reserve and operate differently, then you're not entitled to compensation for, say, for instance, reserves. If you don't provide reactive power, or you could provide it, but you don't commercially agree to it, I can't compensate you because that cost ends up getting paid by consumers. It's got to be avoided. I think you were right to point out that B, the rates of the purchase of energy and capacity, fully and accurately reflecting the utility's avoided cost. So those contracts that I previously described, they're all energy and capacity. There are no avoided ancillary services that the providers currently deliver to us or can deliver based on the way they operate.
Thank you, Mr. Cassis. I'd like to turn you to page 15 of your testimony. And I may not need to share here because I think you'll agree with the testimony. If not, I'll pull it up. You respond to witness Burgess's critique when he states on page 27 of his direct testimony that Dominion did not obtain peer review of input from outside stakeholders. Do you recall your discussion of Mr. Levitis's testimony, Mr. Burgess's testimony there?
Yeah, I do. I'm on page 15.
Of yours. And on that page, you take issue with Mr. Burgess's statement that Dominion did not obtain peer review of input from outside stakeholders, correct?
Yeah, so we presented a previous study in a litigated proceeding, and now we've provided an additional third party, and as you said, independent expert that provided analysis. And any party that's a party to this proceeding can ask for the data. We've responded to, I think, 90 different questions and multiple data requests. So I think that certainly qualifies it as being peer reviewed.
Okay. Just to clarify your testimony, you said that Mr. Burgess ignores the clear history before the commission because the VIC was heavily litigated and examined not only by industry stakeholders in the commission, but also by the commission's third-party independent expert, correct?
That's correct.
And that's in the prior docket?
That was the one we talked about before initially at the outset of this questions.
Is it your contention that litigation is a substitute for peer review of a study?
I wouldn't describe it necessarily as peer review, but I would describe it as robust, and it involves the opportunity for the stakeholders to make comments, ask for anything in discovery that's reasonable, which we've complied with. We've been very transparent about the analysis done by the independent expert.
And that, to be clear, we're talking about two different reports here. You have two different processes here. You are referring in your testimony to the litigation surrounding docket number 2019-184-E. That's the prior VIC litigation, correct?
That's correct.
Yep. And so your claim is that because the VIC was litigated in the past before this commission, when the commission rejected the conclusions of the previous study by Guidehouse that was then Navigant. The current Guidehouse study underwent peer review and stakeholder input.
Well, it's currently under review. You obviously had a chance, and your witnesses had a chance to take all the data, as did other witnesses, and do any analysis they wanted to with it. So I don't know that they've done as much analysis or done a study like we have independently, but I think that the analysis speaks for itself.
And that analysis by Guidehouse in this docket was not provided to any other parties or commented on by any other parties prior to being attached to one of Dominion's, I think it's 3 applications in this docket. Correct?
Yeah. So to full understanding with the dates and the deadlines and the order of scheduling that the commission gave us, it was important to provide as much clear and transparent information as we could. But of course, all that takes time. The analysis is very robust. It's done, I think, properly to examine all those costs to ensure they're accurate costs. But a compressed timeline certainly plays into that. But as soon as we had information, it was shared. It's just a function of how fast we can run the models or how fast we can give the information to Guidehouse for them to independently run it and for them to then share it to the extent that you want to look at any or all of it.
Are you aware of the integrations methodology developed by Duke Energy and that is currently undergoing an independent analysis by multiple national labs and a leading national consultant?
I'm not as familiar with their analysis. I do know I'm not an expert on Duke's system. But I do know a lot about our system and how it operates.
Mm-hmm.
So there could be things that could be transferable to systems, but generally systems operate, balancing area operates very, very different depending upon what its supply is, how many megawatts of renewables have been integrated. I would refrain from making comparisons, say, for instance, between how Duke's system operates. So if they're fast operating reserve assets that are available to them and they aren't available to DESC, that makes a big difference. So,
Mr. Cassis, you're absolutely right to point that out, and I'm sorry if my question was unclear. I'm not really referring to whether Dominion is adopting generation or transmission practices of the Duke entities. I'm asking whether you are familiar with the process that Duke Energy is sending its integration study through with other reviewers before attaching it and using it to base a VIC charge.
I'm sorry, Counselor, I may have misunderstood.
No, my question wasn't clear. Are you familiar that Duke is doing that with their proposed integration study?
No, I'm not. I was not. That was.
That's fine. Did Dominion consider a similar process for its updated study this year after its 2019 analysis was rejected by the commission?
Mr. Chairman, let me object before the witness answers that question. Witness has just clearly answered that he is not aware of that, what's going on in the Duke matter. And for him now to be asked the question of are there similarities would be unfair.
That's a fair objection, and I'll rephrase my question, Mr. Willoughby. Thank you. Did Dominion consider any process by which its integrations methodology would be reviewed by multiple national labs and a leading national consultant prior to submitting it to justify its proposed VIC?
No, and as I guess as I previously explained, Counselor, the scheduling order provided some limitation. You're probably aware that the modeling to determine a VIC is highly dependent on your integrated resource plan, and what those inputs have to be done in a way as directed and approved by our commission. And so that doesn't leave a lot of time then to take something and then send it off to another party in order to be ready for this proceeding. We thought it was more important to be clearly transparent with the way we were having the independent expert calculate and getting the information out there as opposed to not having it out there. In the end of the day, the VIC, it's not designed to It's only designed essentially to hit what you described in Act 62, which was accurately reflecting utilities avoided costs, and that B.
Understood.
Yep. Mhm.
And there was no stakeholder process that the Guidehouse study went through before it was released in with your application, was there?
If we could have done a stakeholder process in that schedule, I would have wanted to do one. I don't see a way we could have ever done a stakeholder process, but because we would have compromised then on the thing we were able to capitalize is the information that actually was shared with us in the prior docket. But I don't really see a way that we could have done a stakeholder process on that order. It has a lot to do with the schedule and the robustness of activity in the regulatory regime. It's not from a lack of desire to share it. The study stands on its own, and I'm glad we shared it, and I'm glad we've got it out there for people to see.
Mr. Commissioner, Mr. Chairman, that may be all I have. If you'll give me just a moment to check my notes.
Okay.
I have no further questions for this witness at this time.
All right. Pine Gate Renewables, LLC.
Thank you, Mr. Cassis.
Thank you, Mr. Chairman. This is Blaine Holman with Pine Gate Renewables. We have no questions for this witness. Thank you.
All right. The South Carolina Coastal Conservation League, Southern Alliance for Clean Energy.
Thank you, Mr. Chairman. We have just a couple of questions for Mr. Cassis. Mr. Cassis, can you hear me okay?
Yes, ma'am. You're a little bit muffled, but I think I'm okay.
Okay, just let me know if you're not able to understand any of my questions. Okay. So in your rebuttal testimony, you address the direct testimony from SACE and CCL witness Kenneth Searcy about transparency in Dominion's application and testimony. Is that right?
Yeah, I did.
Okay. And in that response, which I believe is on page 16 and 17 of your rebuttal, you list the data requests from SACE and CCL and other parties, and the response times from Dominion. Is that right?
Yeah, that's correct. That's on page 16, lines 12 through 26.
Mr. Cassis, you were also a witness for Dominion in the 2019 avoided cost proceeding. Is that correct?
That's correct.
Okay. I'm going to pull up a portion of the commission order from that proceeding. Just give me 1 second. Okay. Mr. Cassis, are you able to see that?
Yep, I am.
Okay. So this is specifically Commission Order 2019-847 and page 20, where the commission made a finding about the transparency of Dominion's filing in that proceeding. I'll give you a moment to review.
Okay.
So do you agree that the commission in this proceeding specifically found that Dominion adequately responded to requests for production in that docket?
Yeah, I'm reading the plain language.
Okay.
Responded to all requests for production.
Right. But they still decided that Dominion must present substantially more information in future avoided cost filings in order to meet transparency requirements. Is that right?
Mr. Chairman, let me object. I mean, if Ms. Mixon wants to show the witness some language, but her interpretation of the language may be totally incorrect.
Okay.
The order speaks for itself. And if there is some language that she wishes to refresh the commission's memory about that they wrote, then she's welcome to put it on the screen. But for her to try to give context to it is inappropriate. And I would object.
So, to be clear, Mr. Willoughby, I am directly referring to language on here, but I would be more than happy to read that if that would be helpful. So we'll start where it says on line 6 of this paragraph, where it says, while Dominion adequately responded to requests for production as expected, Power Advisory recommended that Dominion be required to present substantially more information about the underlying assumptions and data, such that the parties to such future proceedings may more meaningfully evaluate and analyze the methodologies and models employed by the utility. And in the following sentence, as the commission adopts those recommendations from Power Advisory. And so my question to Mr. Cassis was whether he agrees that the commission found that that responding to discovery requests alone was not sufficient to meet transparency requirements.
Let me object to that question. I'm not sure that that's what the commission found, and I'm not sure that that's what that order says. I mean, you've read the language, the order speaks for itself. If you want to ask Mr. Cassis, did he provide the information from which people would be able to analyze and make determinations about the costs that are being proposed in this proceeding? That would be a fair question to ask.
Objection sustained. Ms. Mixon, if you would just ask the question and allow the witness to answer.
Okay. So I guess my question was, I guess, related to whether Mr. Cassis agreed that this order shows that responding to requests for production is not the only requirement for transparency. But I am happy to move on. I will stop sharing my screen. One moment. Okay. Mr. Cassis, were you responsible for preparing the discovery responses that you cited in your rebuttal testimony?
Just a couple of those. Most of them were provided by the team and other witnesses that are in the proceeding.
Okay, well, I'll ask you about a couple of responses in particular then. So were you responsible for preparing any of the company's discovery responses related to their their ELCC data or explanations? And specifically, I think that would be SACE and CCL response 2.9 and ORS 1.4.
No, I wasn't.
Okay, and were you responsible for preparing any of the discovery responses asking for the company's data and analysis supporting their pricing periods?
I was not directly. I believe that was Witness Bell.
Okay, and you did not personally review the content in those responses?
I didn't review in detail. I was probably on every one of the calls where we were compiling the data to ensure that we were as transparent as we possibly could be. But I wasn't, I don't think I prepared any of those responses.
Okay, and to be clear, you said you also did not closely review the content in those responses. Is that correct?
I probably looked at some. I think, again, I applaud our team for getting as much of this turned around and as fast as they could, and I believe they've been very transparent. As a matter of fact, I guess I referenced Witness Horry's statement in his testimony about DESC having been transparent. That seems to be more of the norm than your witness.
Okay, well, Mr. Cassis, I guess, so you specifically stated that there was that Dominion was open and transparent in its responses, but I guess if you did not closely review the content of those responses, you don't have personal knowledge about whether there were any there was any key information, that was not included in the company's responses, as Mr. Searcy claims.
That was a long sentence. Could you repeat that?
Okay, you were not able to closely review the company's discovery responses that I just noted. So am I correct that you do not have any personal knowledge about whether the information that witness Searcy claims was not included in those responses actually, I guess you don't have any knowledge about whether that information was included or whether it was not. Is that correct?
Yeah, there are some things that I looked at. Actually, it piqued my interest when witness Searcy started to identify coloring issues on the heat map. I thought that was interesting, but also asked our folks to make sure the data was as accurate as could be, and that if there was an issue around the coloring of a heat map, let's make sure that's not an issue, and let's make sure we have that information, the underlying information correct, and give him whatever he needs. That was one thing that actually stood out in my mind. I guess disagreeing with data is different than, or disagreeing with the outcome is different than providing it and giving it to others to then look at and to analyze. It's just two different things.
Okay, thank you, Mr. Cass. I think we'll have more questions for some of Dominion's other witnesses on those points that you just mentioned. But thank you for your time this morning.
Thank you.
South Carolina Department of Consumer Affairs. Attorney Hall, I think you're on mute. Attorney Hall, we cannot.
Can you hear me now?
Yes, sir.
Sorry about it. For some reason, WebEx decided to change my microphone input. No questions. Thank you.
All right. Office of Regulatory Staff.
Thank you, Mr. Chairman. This is Chris Huber for ORS. We have no cross for Mr. Cassis. Thank you.
All right. Commissioner questions.
Chairman Williams.
Commissioner Caston, we will take your questions as soon as we get back from a 15-minute break. We're in recess for 15 minutes. Good afternoon, or excuse me, good morning, ladies and gentlemen. Welcome back to the Public Service Commission of South Carolina. We are here in docket number 2021-88E. Let's take roll. Present in the hearing room, we have Commissioner Caston, Commissioner Thomas, Commissioner Williams, Commissioner Powers, Vice Chair Belzer, and Chairman Williams. Joining us virtually, we have Commissioner Irvin. Before we took a brief recess, we reached the point of commissioner questions. We're going to start with Commissioner Caston.
Good morning, Mr. Cassis. Can you hear me okay?
Good morning, Commissioner.
I can't see you. Where are you?
Can you see me?
Well, I see me, and I certainly don't want to see me.
I think I'm up.
Okay.
Okay.
Good. I've heard stakeholder kicked around a lot, not only this morning, but in previous hearings. And I thought I knew what stakeholders meant. I thought I knew what stakeholder driven meant, but not sure I do. I think I do. But relative to you, relative stakeholders and stakeholder process, stakeholder driven process, or whatever you want to call it, what do you consider a stakeholder process to be?
Yeah. I'd say, Commissioner, a stakeholder process involves input or information from interested parties. And I think an example of that, could be the IRP process, where there's a lot of things going on, but there's still time to gather input. But I don't know that stakeholder process necessarily has to be formal. It can also be qualifying as individual conversations, developer calls. So I think that could be an alternative based on, I think, when things have to get done, and in the event that you couldn't compromise on transparency, you might not be able to get everything you wanted to do in a more formal stakeholder process.
Okay. Then who is a stakeholder? Just who is a stakeholder in this case? In this particular hearing, who could be a stakeholder, or who is a stakeholder?
Yeah, no, that's a great question. So that if you look at the section of the law that was previously referenced, it was that 584120. It actually, I think it helps define the stakeholders. I think everybody focuses on the small power producer as a stakeholder. I would tell you that, and for the sake of simplicity, I'll just read you the section because I think it helps define who the stakeholders are. This is coming directly out of Act 62, but any decisions by the commission shall be just and reasonable to the ratepayers of the electric utility in the public interest, consistent with PURPA and the Federal Energy Regulatory Commission's implementing regulation and orders, and non-discriminatory to power producers, and shall strive to reduce the risk on the using and consuming public. I would say public interest, consuming public, and ratepayers are mentioned three separate times. So in the end of the day, in an avoided cost proceeding, the stakeholders are the utility, the small power producers, but most importantly, they're the people who are going to pay the rates. So if a small power producer isn't compensated accurately, then the cost of fuel ends up going up. I think that's one of the reasons why we spend so much time on things like the VIC and getting the avoided cost right. So in a state that's next to us, I think North Carolina reported at one point, maybe in a previous proceeding, they had $1 billion worth of overpayments in PURPA contracts. That wasn't something that I could fathom could happen in South Carolina if we did the rates right.
Okay. Then, and I'm, certainly not going to argue with some of those folks being stakeholders, those groups. But who should initiate that stakeholder process? The Public Service Commission, a customer? Should they call you up and say, hey, can we have a stakeholder process? I mean, who should initiate that process?
Yeah, the stakeholder process is not going to be initiated by customers because they don't obviously in this proceeding, they don't have the mandatory PURPA obligation to consume power. So the two parties that are in the negotiation are small power producers, which I have a lot of conversation with a lot of small power producers. And it's the utility and it's the modelers, but they're the same people that are actually doing the analysis around the IRP too. So we've got to be able to fit this in. If we're going to do something that's going to be more robust, it's got to be fit into the schedule. But you can't calculate the avoided cost unless you have the supply plan or the resource plan, which then leads to the calculations, which gives you avoided cost.
Okay. Certainly, this particular issue comes up, every 2 years at a minimum?
Every 24 months, correct.
So it's not like something out of the blue. I mean, we know it's coming. And as I sit here thinking about stakeholder-driven process, that in general, and through the course of time, I've probably mentioned it more than once. If someone is made to do something, I wouldn't consider that stakeholder-driven or stakeholder process. That would be under duress or made to or whatever. So it kind of defeats the purpose. If the purpose is to bring the groups, individuals that have a stake in the process, the outcome of the process, would it make sense for Dominion to, with adequate time, to pull together those vested interests on their own and try to, everybody lay the cards on the table, talk about it, argue about it, arm wrestle, disagree, whatever. Would that be maybe a more accurate stakeholder process?
Yeah, I'll answer that. And I hope you apologize if my answer is a little long, but I think it kind of gets into maybe the technical issues here. So a discussion with the business development leaders in the renewable energy space is something I embrace. I love that. The guys who want to do commercial business and want to figure out a way to work with the utility, there are some wonderful people in the solar industry. This particular issue is really what I would describe as narrowly focused. It's about PURPA. It's about the right to build small power production assets. And it's, in the end of the day, the guys who are really smart about what they're doing commercially and want to work, they also recognize that they have a right to put power, and they also are smart enough to know that they have to get financing. And they also are smart enough to know that if the price isn't accurate in avoided cost, that's an alternative path. I don't think everybody thinks about it that way. I've had these incredible discussions now with developers around storage, around ways that we can work together and ensure reliability and affordability and still get to decarbonization. I think this is just a much more narrower space that I don't think PURPA is the way we're going to advance ourselves as South Carolinians and as those who want to decarbonize. I don't think it's going to be done through PURPA. So I'm not against the stakeholder process. I think but if the stakeholder process is just around this one issue, then it's likely going to put the parties apart from each other. You'd lay the cards on the table, and in my conversations, quite frankly, with developers that want to do QF projects, their only question to me is, how can I get more money to make my project financeable? The guys that I really like talking to are the guys that, how do we work together to figure out a product that you need that can help you and that fits somewhere in your resource plan? So I apologize for the long answer, but I think it was necessary to kind of set the field to understand kind of what we were trying to get accomplished here.
Well, let me see if I understood the long answer.
Yeah.
Did I think I heard you basically say that avoided cost is very technical and complex, and it's, you got the PURPA requirements, and it's because of all those things, the maybe traditional stakeholder process is not practical, or did I just put too much?
I think you can have a stakeholder process, but I think what it should be is something broader around renewable integration and around ways to fulfill customer needs and line up with affordability. But if two sides are just diametrically opposed because one needs to get more money in an avoided cost contract and the other is interested in keeping the system reliable and also affordable, we could just be at odds. The narrow nature of avoided cost proceedings lend to contentious discussion. I think it's around the real opportunity, I think, in stakeholder process with renewable developers is around a broader discussion and not as narrow a discussion as in this proceeding.
Does avoided cost outcomes affect the customer?
Oh, absolutely. And an inaccurate avoided cost ultimately creates payments through fuel that if they're greater than the actual, then those payments go directly to the customers paying that in their fuel. That's where that ends up.
Understand. So I guess what I'm trying to understand, or perhaps elicit a better understanding from you, is that I found rate cases to be kind of complicated and challenging also. Would you agree?
I think that's in the hierarchy, the rate case is probably at the top of the list of the most difficult.
And I also find that avoided cost, whatever that is, affects everyone, every customer, the consuming public, the QFs, the non-solar, the solar, Dominion, kind of affects everybody as I see it, kind of like rate hearing. And I guess the point I'm trying to make is we're sitting here, we're doing this, and hey, that comes with the turf, it's the job. I get it. But we're sitting here doing this, and I'm not sure that a stakeholder-driven process eliminates all this process or should eliminate this process, but I guess what I'm saying is we're doing the exact same things you're saying need to be done or would be nicely done if you could do that in a stakeholder process, maybe if it wasn't so technical, but we're doing it now and we're at odds. Apparently you've got the parties at odds now. So is there any appreciable difference between perhaps Dominion attempting to bring all the parties, not just those that take issue with you, but all the similar or same parties you do in a rate case, do the exact same thing on something like this? I mean, why would that not make sense, or why would that be different?
Commissioner, I think and I understand, that's a great question. I think it's, I think because this is this narrow issue with respect to what a small power producer gets paid for their PURPA project. The bigger issue, which is where the big tent should occur, is with, it doesn't matter whether you're a SECEBA member or, a steward of the environment, or battery storage, or not a member of any of those groups, and is thinking more comprehensively. I think that discussion, I mean, right now is taking place, I believe, in the IRP, in the resource plan. And I think that then drives, it would be a similar discussion. That would be the better way to address it, not just in a proceeding like this, but in what I would describe it as renewable development in concert with resource plan is the way I would think of it. So I don't disagree with you, and I appreciate your passion for stakeholder process. I can honestly tell you, I've got plenty of friends that I've worked with over the years, and plenty of them have signed my contracts. So we have a lot of mutual respect for each other. It's mostly around the commercial strategies and approaches. It just happens to be this really narrow issue is a very tough one, but when you broaden it out, I think it has the potential to lend itself to more to more people that actually can share thoughts and actually intellectually, honestly move, I think, forward on some important issues.
All right, Mr. Cassis, thank you. And I didn't mean to belabor that point. And again, this is Dominion's call, not mine. Don't want it to be mine. My personal experience has been, and it's just me, that us against them, I've rarely had work out well that benefited anybody well. But when all the appropriate parties came in and hashed it out, argued it out, we didn't agree. And if I was going to say something selfish and self-serving and everybody's in the room to hear it, my experience has been that it has a better chance or opportunity to reach outcomes that are more reasonable, that are more fair, that are more just. But that's my opinion. That's my experience. Perhaps yours has not been that way. But I hope Dominion will think about those things in the path forward. Turning to specifics, I think in your rebuttal, you talked about integration study and need for that. In your opinion, what data needs need to be in place or developed to perform an accurate integration study?
Yeah. So, I mentioned, Commissioner, the integrated resource plan, or the plan. So you have to model the system as it exists, and then you're looking forward in that model and then you're taking what I would describe as a change case, something different that really isn't controlled by the utility. So it's not location, and in almost all cases, it's not when it's delivered. And you're evaluating, the study's evaluating what that does to the system. And so the cost causer then needs to be evaluated for what impacts. So it's a appropriate resource plan, which becomes the base. And then that whole supply side, all those generating assets, how they operate, are modeled. It's just a statistical modeling. It includes weather, it includes load, it includes, I think our witness, Peter David, describes it as the 100 Monte Carlo draw. It's a robust computer program, which then provides outcomes which tell you how you operate the system differently as a result of accepting or having to accept the small power producer unconstrained delivery is really what it is.
I understand, but I understand what you're saying, I think, relative to, okay, you got to have a base. Where are we now? Where do we need to be in the future? And then what's that delta? I got that. What I'm trying to understand, because right now we have an interim VIC, and that seems to, be an issue of concern. And to get I guess, a better understanding of what is it, what should it be, a more in-depth integration study needs to occur. Is that correct?
I mean, we believe the number that we've provided is accurate, and we've shared all the data, but I don't think we understand the commission has ordered an additional study, and so we're a party to that. So we have no objection, but we also felt like we needed to provide the most accurate data that's up to date, which is why we advanced, this in the filing just to show it. We did take information from the prior proceeding, and again, our system changed. We've now got coal assets that are at least showing they're going to retire, subject to a study, and we've got other additional solar assets and storage assets as part of the plan. That's a completely different set of data. Yep.
Well, okay, I understand that, and I appreciate that. What I'm asking, and I read testimony, and I think Mr. Bell says that too, but what I'm asking, are you saying the way Dominion does it now, not necessarily the 1 hour forward, is the appropriate way? What I'm trying to determine is Dominion, as I understand it, is in the process of installing their AMI system. Is that correct?
That's correct. I think we're doing maybe 25,000 installs per month.
And do you know what the estimated completion date time is for that?
Commissioner, you always ask questions I don't know the answer to, so I do not know when the completion. I believe it would be it's sometime in 22, I believe, and I maybe there's a supply chain issue that may push that out, but I'm not perfectly aligned on when what the 100% delivery is.
But if I understand it correctly, one of the many benefits, or one of the benefits, let's say, of AMI is allowing the utility the ability to acquire and accumulate data, say in 5-minute increments, 1 minute, 1 hour. however you choose to set it up. Is that correct?
Yeah, I would distinguish AMI as a, you know, a load side or right at load side, analytic tool. So, but yeah, the data, the benefits of the data that would come out of AMI, at least on the consuming side, would be significant.
So the point or the question I'm asking is, and I understand that Dominion feels like what they have submitted for the VIC and the integration study now is good and adequate. If I were going to do an integration study using your information or Dominion's information, would I be better served to have that hour ahead or that information that AMI can provide? Is that correct?
So and maybe we're missing each other. So for the small power producers, so I think there are 40 small power producers that we have contracts with now. So those are, I'm specifically speaking about the supply side. So for instance, 100 megawatt DC, 75 megawatt AC on 300 acres. It's that big supply where the data, it can get very, very granular. So we're managing the entire system. So it's, Commissioner, it's well before it ever gets to the customer. So we're talking about the assets that are delivering energy to the transmission system or the distribution system. They're well before they get to the customer.
Okay, I understand. And so I guess the larger QFs that are tied directly to the transmission lines already have the apparatus and the stuff in place to accommodate these things, any losses or anything that might affect the AC current and that kind of stuff, correct?
Yeah, so that modeling, which is actually I would describe that as being very robust. It's not only robust from what happens daily, and Witness Hanslick can speak to this, but as he's operates the system every day. And of course, we're attempting to forecast it every day, but it's around the supply side is where our focus is in this proceeding, and not as much on the demand side. We just supply the energy. We've got to supply. It's actually a fundamental requirement in the public interest for us to supply the energy. But the small power producers also have the right to sell us power at avoided cost. And that's the construct that I think we're working through today.
Understand. Hey, let me move on right quick because I know there may be other questions. Relative to the PPA, and I think Mr. Burns had some questions on it. I know Mr. Levitas did in his, I think, direct testimony, some questions or concerns. Or does this fall in your area as far as the PPA and these questions relative to insurance and reactive power and all that?
Yeah, it does. I mean, in the end of the day, those original contracts, I mean, they were part of, and they're really relatively very close to each other, but I was the witness when we actually got the form PPA and the standard offer form, all those documents approved in the prior avoided cost proceeding.
Well, I think you answered these or tried to answer these with Mr. Burns relative to using cash collateral, which as I understand it, I think Dominion has said, well, that'll be okay now instead of doing away with cash collection. Is that correct?
Yeah, that's correct. Most people don't conduct business in cash, but we're fine. We're good with that.
And relative to the insurance requirements, why was that again modified or doubled or tripled or whatever it was? I can't remember, but it was a
Yeah, so I mean, we're talking about insurance amounts that are in the millions of dollars. I think for a 75 megawatt asset at maybe $1 million per megawatt at 75 million. I don't think it's an onerous requirement. We were just reflecting one, corporately aligning with the way insurance requirements were set up in Virginia. And I felt like that was consistent with the risk and protected, all parties. So I don't think it was a huge issue.
I'm sorry.
Yep.
So these changes were specifically just to try to align with corporate in Virginia.
Yeah, to protect, but to be clear, to protect, consumers too. If an insurance is essentially risk, I don't know that I'd ever build a project without insurance. And I think the amounts are reasonable. We referenced our corporate parent to make sure what would they require if they were going to build an asset, and those were consistent levels of insurance.
So if they were reasonable 2 years ago, why would they not be reasonable now if it's the same relative value of QF?
Probably the one thing that I've seen that's different is there are, most folks are beginning to introduce storage, chemical storage. So that's that hybrid asset is probably different. So we just try to stay, I think, in line with what we see in the market is risk.
All right, thank you, Mr. Cassis. I appreciate it. And I know I've gone on long. Thank you.
Thank you, Commissioner. Great questions. Thank you.
Vice Chair Belzer.
Thank you. Thank you, Mr. Chairman. Good morning, Mr. Cassis.
Good morning.
Thank you for your testimony this morning and this afternoon. A couple of things. When you were answering questions from Attorney Burns, did I understand you to say that there have been no PPAs signed in the last 2 years?
So we actually I think I have a PPA that we've filed before the commission, I think June 4th. So it's a question about what would be redacted. So I think he asked maybe he asked a slightly different question.
Well, let me just ask this.
Yeah.
In the last 2 years since the last avoided cost proceeding, have there been any PPAs negotiated and signed with Dominion and project developers?
Yeah, so there is a project where it's a PV plus storage project, and that has been signed and it's executed. And I think that's should come up before the commission.
Okay, so there's been one.
That's correct.
And I recall your explanation with slowdowns with COVID and other issues, but I was just trying to get straight on that. And in your response to questions for Attorney Burns, you mentioned a couple of times hybrid projects, and you mentioned that in response to Commissioner Caston as well. Can you just tell me, for the record, or give me an explanation of a hybrid project, please?
Yeah, sure. So all the early projects up to today that have been completed and are commercial and in operation, they've been just PV, just solar. So they're inverters that then convert that energy from DC to AC and then deliver it to, in most cases, our transmission system, and in some cases, distribution. When I describe hybridized, right now, I'm specifically referring to the addition of new projects that have battery storage. So most of the projects, and the project that we have signed recently has PV, but it also has battery storage. And the battery storage can be quite large. They actually used our storage tariff to contract or to get to values. And so hybrid means it's not just the uncontrolled fuel limited PV. It's got an additional add-in to it. So it can help with or firm, possibly, depending upon how it's operated, or provide capacity where capacity didn't exist.
And you, in response to a question from Commissioner Caston, you mentioned chemical storage. What would that be?
Yeah, so, most people refer to the current storage technology as, say, it's lithium ion. So that's chemical storage, which is, it's sufficient for shorter durations. Sometimes we have a storage tariff and it requires to meet the tariff that it's a 4-hour product. But we're working with some developers who are looking at shorter periods. So it's not an unlimited resource, so it has its limitations. And of course, you have to hold energy and you have to charge it, and then you have to move energy when you need it. But I was specifically referring to lithium ion, or there are other products that are in the market that are similar to that product.
Okay, thank you for those responses. Mr. Cassis, you're first up. Are you familiar with the application filed by Dominion in this proceeding?
Yeah, I am.
Are you available to, let's walk through it a little bit so that we can understand the different pieces? Do you feel comfortable doing that? You can always defer if we get to something.
Yeah, let me see if I can find, actually I have it, I believe. And I'm hoping I can help you, Commissioner.
It's actually the second amended application that I'm looking at.
Yeah, I tell you, I'm willing to give it a shot. I thought I had a copy.
Well, and I don't know how to share screen and do all that stuff. So, well, let's try it if we can.
Okay.
The application contains about 21 pages of description and then a number of exhibits. Would you agree with that?
What I remember, that's correct.
And Exhibit 1 is denoted as rate PR avoided cost methodology. Does that sound familiar?
Yes, Commissioner.
And would you agree that that really just kind of sets forth some definitions and components of avoided cost, just is a description of potential methodology, I reckon. Does that sound familiar?
Yes, I agree.
But there's no data with that. Would you agree?
I agree.
Okay. And it says rate PR. What does the PR stand for?
Oh.
I know I'm getting really basic, but I'm just trying to make sure we all understand the components of this application.
Yeah, no, if you wouldn't ask me the acronym, I would have, I just drew a blank, though. I'm sorry.
Okay. Well, somebody will be able to fill that in later.
Okay. Yep.
And then, Exhibit 2 is a table that has the standard offered rate for avoided energy costs, the standard offered rate avoided capacity costs for non-solar, a table with avoided energy costs for solar and avoided capacity costs for solar. Does that sound familiar?
Yes, Commissioner.
And would that table be the proposed rates that are contained in this application?
I wish I had a copy. So fundamentally, I understand, but I wish I was looking at that document.
I wish you were too.
Yeah. Commissioner, I'll tell you, I believe that,
I tell you what, I don't know that we're gonna be able to finish through lunch. So can you get a copy of this application so we can talk through this after lunch? And I'll let somebody else go ahead.
Yes, Commissioner.
Thank you, Mr. Cassis. We'll talk shortly.
Okay.
Thank you. Mr. Chairman, may I continue after lunch? Let somebody else go ahead.
Absolutely, ma'am. I think it's about lunchtime now. We're in recess until 1:45.